Thank you. We can now take our seats. Once again, good morning, ladies and gentlemen. My name is Miss Patience Higumba, and I'm going to be your Director of Ceremonies today. Since we say that anonymity is the order of the day, we are not going to be doing any introductions, but kindly help me welcome our judges for today. By an applause, thank you. Okay, without further ado, I'm going to kindly ask the Dean of the Abechitebo Law School, Mr. Victor Mpiwani, to come and give us an introductory speech. Kindly help me to welcome him to the podium.
The Director of Ceremonies is wrong. I'm not going to give the speech. I'm going to welcome you. First of all, our distinguished judges, whom I shall not disclose now, but will say more about them because I know a lot about them later. My address, the welcome remarks are specifically directed at the young people who are going to be the Mooters of today. And let me start that by quoting Dr. Ellen Johnson. Some of you may know or not know her. She was the first African female president. And she was the president of Liberia. I want to quote what she says. She says, "The size of your dreams must always exceed your present capacity to achieve them. If your dreams don't scare you, then they are not big enough." I hope all those of the young people who are here have dreams that scare them. This exercise of mooting, and which is all over the world today, during our time at university, we didn't even have this kind of opportunities. Sometimes I wish I could go back and test my skills, oratory skills, knowledge of the law skills, and these are the skills that will make you a good lawyer in many different capacities. Research skills, because when you research for these moot competitions, I believe you do more research than you do for your assignment, because you go to so many sources. And I'm looking forward to all of you showcasing those skills that I'm talking about. And I wish we could do more of these, resources permitting. But it is credit to our partnership with ICOD Zimbabwe that we're even able to hold one in these difficult and challenging times. Many of the mooting competitions we are used to participating in an annual basis are temporarily suspended because of these challenges. So, again, the matter that will be addressed today is a very, very important matter, the matter which has to do with rights relating to disabled women and children. We know that disabled persons suffer marginalization in general. But for women, disabled women and children, there is double marginalization in the sense of being disabled and secondly, being a woman, because women are generally marginalized in our communities. So we think that it is important for you, the students, who are our experts today, to argue and show us what the shortcomings in our laws are. If there are any strengths, we want to hear about those strengths in the law. If there are any changes, of course, we hope this can be made. You know that in East Africa, mooting is now in their DNA. That's why you find them winning major tournaments. For example, Strathmore University last year won, and I mean in 2019, won the World International Trade Law Moot, the first team in Africa to do that. And the University of Nairobi won the African Human Rights Moot for 2 years in succession, the only team in Africa to have defended that title. So it shows that you can really go far. And again, even if one team is named as the winner today, in terms of individual scores, I believe all the teams that are already here are winners. We are all winners by being part of this important exercise. And in any event, from my experience, the marked differences between the winner and the runners-up or even the third team are usually very, very small. Sometimes even half a mark makes that difference. So the teams that are here are not going to be very far apart in terms of their competence in the skills that we are talking about. So I don't want to give a speech. Let me wish all the participating teams a wonderful, wonderful, exciting day. Thank you very much.
Thank you, Dean. As you heard from the Dean, he said that mooting is now in our DNA. So today we are going to see whether that is true or not. Okay, now I'm going to kindly ask our organizers who have made today happen. I'm going to ask the director of ICOD Zimbabwe to come and give us an introductory speech. Kindly help me welcome Ms. Marcos.
Greetings to you all. I'd like to recognize the judges, the dean. It's a partnership which we actually value as an organization, and we always say in the office he's one of the most progressive person that we've ever interacted with. You know, is that person who makes you want to do things, even when you engage. Like the first time we engaged was just a conversation. But then the image that we got from him, it's actually made me and my team have sleepless nights saying, we need to get this thing done. So the deputy dean, the coaches, the media, the students, all the stakeholders that are here, my team, and all protocols observed. So for me, I think I have a 2-minute statement. So this kind of what I want to tell you guys is who we are. Institute for Community Development is an organization that was founded by women, for women. The reason why ICOD Zimbabwe was formed was realizing that for years there have been a lot of development initiatives that have been done, but there was always an assumption that women are a homogeneous group. I have no issues with us here being a women's bank, for example, but is it enough I'm able to say we have a women's bank and all women's issues, financial issues are sorted out. That is why ICOD was formed. Realizing that the needs of a young woman who is at Zimbabwe University or at UZ or at whatever institution are different from the needs of that young woman who is staying in the periphery, in the rural communities. The needs of a woman with disability are different from a woman who doesn't have a disability. What access means, what access to rights means, are totally different processes. So for us, the commission was to say, let us offer target-specific interventions that we will be able to achieve our targets, our goals in a sustainable manner. So the organization is operating in National Province and in the southern part of Midlands. That is where our operating area, targeting women in hard-to-reach communities. You hardly find us in hotels. For us, when you're sitting in this room, like, oh, that's luxury. So we go to those hard-to-reach communities. The reason being, we realize that there is need to increase access to information. There is need to ensure there's inclusion of people and especially women from different communities. What I also want to highlight is, as Dean indicated, we have a partnership with Zimbabwe University. And one of the reasons why we thought we really needed to have this as an organization was realizing that, you know what, we do gender-based violence, we do sexual preventive health as an organization. And one of the biggest challenges we used to have, even as we interacted with the victim-friendly unit, was the challenges that women with disability face when it comes to accessing justice. The first challenge being able to realize that there is a violation that has happened, for example. So for us, we thought, no, the best way is to engage the law students, the lawyers in the making, the judges that are in the making. That is why we felt like it was need for us to have this partnership, and that is why we are here today, despite the challenges that Dean has highlighted. So for us as an organization, and the purpose of this Moot was, one, we wanted to stimulate an interest in disability rights issues with particular focus on vulnerable groups, particularly women and children with disability. So to start having the conversation, being aware, that is where what we wanted to achieve. And of course, sharpen most participants' advocacy skills and gender excellence oral advocacy skills through competition. I love the statement that Dean highlighted to say we're going to be able to identify the strengths within our laws. We're also going to identify the opportunities and the gaps. That will become our advocacy strategy based on the findings and the discussions that are going to happen today. So thank you very much.
Thank you very much. And once again, the Director of ICOD, Ms. Maposa. Thank you. Okay, now we are going to proceed to our preliminary rounds. And I'm going to kindly ask Team Bravo and Team Alpha to step outside. Ladies and gentlemen, today's matter is before the African Court, and this is the matter between the Forum for Women with Disabilities versus the Republic of Peruano. And in this round, Team Delta is the applicant, and Team Charlie is the respondent. The applicant is sitting on my left, and the respondents are sitting on my right. And participants, you are going to be allowed to introduce your personal names. Yes. Although anonymity is the order of the day, but you can introduce your personal names in order for scoring. Okay, thank you.
May you please this honorable court, honorable judges, before you on behalf of the applicant, this Shiram Banyasha, together with my co-counsels, Ongai Mazoroze, Vincent Nakura, and lastly, Tatenda Masarako.
So could you just go through the names again?
Fungai Mazoroze,
Starting with you.
okay, Shiram Banyasha. And Fungai Mazoroze, Vincent Ndagurwa, and Tatenda Masara Unga.
Thank you.
Honorable judges, it is to believe if I may seek your indulgence, are we supposed to do the opening statement alone or we are now starting?
Your opening statement, please.
Thank you. Honorable judges, it is the belief and conviction of the applicant that the communication that was brought before this honorable court and his three main claims suffice the case that can be heard and be determined by this honorable court. It is on this basis that the applicant has brought his application and the submissions are going to be structured as follows. Firstly, we're going to be dealing with the relevant and particular preliminary issues that have to be dealt with before this honorable court for the matter to be heard by this applicant court. And lastly, we are going to substantiate on the three main claims which the applicant has brought before this honorable court. In that respect, my co-counsel Vincent Ndagurwa is going to deal with the preliminary issues. And co-counsel Fungai Mazoroze is going to substantiate the first claim that has been brought by the applicant before this honorable court. And secondly, my co-counsel Tatenda Masaramba is going to substantiate again the second claim that has been proffered of record by the applicant. And lastly, I am going to deal with the third claim which we have brought before this honorable court and substantiate and pray that the court finds and determines that this application can be heard and the respondent is in violation of international human rights law. Thank you.
A pleasant morning to you, Honorable Justices. My name is Ms. Rufaru Deshe, and I'm the lead counsel
Sorry,
of
come again.
Rufaru Deshe, and I'm the lead counsel for the applicant, for the respondents in this matter. With me are my co-counsels, Mr. Lincoln Majogo, the second counsel, Ms. Audrey Glovu, the third counsel, and Ms. Rebecca Makoshongwe, the fourth counsel. I will address this honorable court on the preliminary issues in this matter with regards to the jurisdiction and admissibility of this case before this court, and my second counsel, third counsel, and fourth counsel will address this court on the merits in terms of claim in terms of claims 1, 2, and 3 of the case.
If it pleases this honorable court, honorable judges, we shall make submissions on preliminary points for the applicant. Our
You could just start with your name again. So that we show
Vincent Nagro.
that applies to you. Proceed.
Our submissions shall go as follows. We are going to firstly focus on the aspect of locus standi, secondly on the aspect of jurisdiction, and lastly on the aspect of admissibility. If it pleases this honorable court, honorable judges, I shall start by making submissions on the aspect of locus standi. The applicant submits that it has the necessary locus standi to bring a case before this honorable court pursuant to Article 5, Sub-Article 3, and Article 34, Sub-Article 6 of the African Court Protocol. In terms of Article 5, Sub-Article 3, this honorable court has the discretion to allow individuals and non-governmental organizations to bring a case before this honorable court only if they have been granted an observer status with the African Human Rights Commission. And the applicant is pleased to inform this honorable court that it had been granted such an observer status in 2015. Further, in terms of Article 34, Sub-Article 6, this honorable court is entitled to accept matters brought by individuals and non-governmental organizations against a state only if that respondent state had made a declaration accepting the jurisdiction of the court. And the applicant is pleased to inform this honorable court that the Republic of Peru had made such a declaration accepting the competence of the court in terms of Article 34, Sub-Article 6. It is upon this premise that the applicant prays that it has the necessary local standard to bring a case before this honorable court. If there are no questions, honorable judges, I may proceed to focus on the aspect of jurisdiction. The applicant submits that this honorable court has the necessary jurisdiction to hear and determine the application before it in terms of Article 3, Sub-Article 1, and Article 34, Sub-Article 6 of the African Court Protocol.
Counsel, before you proceed,
Yes.
are you aware that several countries have actually withdrawn their instrument of ratification in terms of Section 34, subsection 6? Countries such as Tanzania, Benin, Cote d'Ivoire, and Rwanda. So does that have an impact on the applicability or the jurisdiction of this court to hear the matter?
Yeah, in terms of the African Court Protocol, it can only apply only if the number of the people, the number of the states subscribing to it are 15 and more countries. That's what the provisions of the African Court Protocol says. May I proceed?
So after this withdrawal of these countries, how many countries are left?
You have said Tanzania,
Cote d'Ivoire,
Cote d'Ivoire, and
Benin.
honorable judges. What I can safely say is that I'm not aware of the total number of African countries which have subscribed to the African Protocol at the present moment. If it pleases this honorable court, I shall proceed.
Yes, you may proceed.
Yeah, we still insist on the basis of interest of justice, on the basis that persons with disabilities are in a very sad predicament. And the spirit of the charter is to protect and promote human rights. So the applicant would like to pray that this honorable court exercise its jurisdiction. In terms of Article 3, Sub-Article 1 of the African Court Protocol. If it pleases this honorable court, I shall proceed on the aspect of admissibility. The applicant submits that the application before this honorable court is admissible as it is compatible with Article 56 of the African Charter as read with Rule 50 of the African Court rules. All the requirements for admissibility have been satisfied. The application has been written in a respectful manner, and it is not solely based on media reports. The applicant would like to further emphasize on the aspect of exhaustion of domestic remedies. It had dispensed with that on the basis that the remedies in the Republic of Peru are not available. In the case of Annual Justice Council versus Ethiopia, remedies are only available when there are no impediment to access those remedies. And if the applicant or the complainant is able to utilize them in his or her circumstances. So the circumstances that are within the applicant cannot allow the applicant to make use of internal remedies available in the Republic of Peru. It cannot find the authorization required for them to represent persons with disabilities in the appeal court of the Republic of Peru, because the victims are heavily guarded by the police and by the military details. So the applicant is not in a position then to obtain the requisite authorization. So the applicant argues that the remedies in the Republic of Peru are not available because the applicant cannot make use of them in these circumstances. If there are no further questions, honorable judges, I shall defer proceedings to my co-counsel for my authority to make submissions on claim 1.
If it pleases this honorable court, as I have been introduced by my co-counsel, my name is Rumai Mazoroze. As has been highlighted, I shall be dealing with claim 1 that has been brought before this honorable court. Claim 1 requires that this honorable court determines whether or not the removal of women with disabilities and children with disabilities from their home and placing them in institutional care that were created by the government of Peru is a violation of human rights. It also requires that this honorable court determines whether or not sending of children with albinism to schools in these institutional care that are meant for children with albinism as a disability only is again a violation of human rights. I would like to take the court back to the reign of Hitler, where an unwanted dress was taken and placed in concentration camps. Here I refer to the Jews who were kept in concentration camps because they were an unwanted race. The applicant does not see a difference between what was done to these Jews and what is being done today to women with disabilities and children with disabilities by the state of Peru.
Counsel, do you have any case law on that? You're referring to the situation in Germany. Do you have any case law to support the conclusion that you made.
It is this honorable court, we will refer to the case of Nuremberg, to the Nuremberg Tribunal. What we have viewed as
What was the determination in that tribunal?
it is this honorable court for purposes of being accurate, may I? Thank you. Honorable members, it is this honorable court. In the case that we have referred to, the determination was that there was grave prejudice of human rights.
Not make it a specific case, if you say the women have tried.
Because there were various files.
If I may convert to speaking matters to my counsel. In the interest of time, we were not able to find a specific case, we generalized it. It is this honorable court, may I continue my submission? The first right that was violated by the state of Pirana in place.
We take it that generally we are simply giving us a historical background, or we are giving us some precedent.
We are bringing to a historical background of what institutionalized homes have been used for in the past. Thank you. Equality and non-discrimination is a general human right. The state of Pirana in its constitution, section 56, subsection 3, as well with article 2 of the African Charter, strictly states that every human right has the right to be treated equally and there should be non-discrimination when dealing with all individuals. The applicant is of the view that the very fact that women with disabilities and children with disabilities were taken and placed in institutional care, whereas there are men with disabilities as well in Pirana who were left to live in the ordinary society, is a grave violation of the right to equality and non-discrimination.
So can we not say that because this particular women and children are very, very vulnerable, that the act by this, constitutes positive discrimination?
Indeed, we can claim that, but the statistics have not, the fact sheet does not say men with disabilities in Pirana are not being targeted. It does not prove that men with disabilities in Pirana are not being mutilated and killed. Hence, because of that, because the fact sheet is tied to the number of men and the number of women that are being killed, this becomes a violation of the right to equality and non-discrimination. Article 2 of the Vienna Convention of the Persons Living with Disabilities states that it was ratified by the state of Pirana, and it states that one should treat persons with disabilities ordinarily the way any other human being is treated. Yes, we are of the view that by the very fact that the government has failed to protect these people while they're in their homes, in their communities, and they place them in institutional care, it shows that the government is violating their rights. In the state of Good versus Banana, it was decided that a state's dualist or monolith system is not of any importance when dealing with human rights. Yes, the fact that Pirana has not domesticated some of the laws that protect people with disabilities, but he has rectified it, means Pirana is bound to respect these human rights. Apart from the right to equality and non-discrimination, the right to family has been violated. Because we have a situation from the fact sheet where women and children with disabilities are being taken and placed in institutional care homes, What then happens to the child born to a mother with disabilities who does not have disabilities? Who then becomes the mother to the child when the mother is being kept in an institutional care home? Of interest also is the right to for parents to choose education that they want for their children. That is Article 26, subsection 3 of the United Nations Declaration of Human Rights. It strictly says a parent has a right to decide where they will send their child. Of course, this is subject to economic availability of money to this parent. But if we say children with albinism are going to go to school in institutional care homes, we have violated the right of the parent to choose. I want to send my child to a private school, but the government has decided my child will go to an institutional care home school. This is a violation to human rights. Because of these violations, the applicant claims that this honorable court notices that these rights have been violated, and this honorable court is able to defend this right. This honorable court is able to find parent in violation of the right for these parents to choose education for their schools. This honorable court is also able to find parent in violation of the right to association. Freedom of association has been taken. People with disabilities have been placed in institutional care homes. They are not able to access the outside world. The outside world is not able to access them. They are not able to associate with who they want to associate with. The outside world is also not free to associate with them. It's a violation of the right to association.
Is that the relief that you are claiming, that this court finds that there has been a violation? And if that is so, is there anything else that you want from this court, in addition to perhaps that declaration that there has been a violation?
Apart from the court declaring that their rights have been violated, we seek that the court gives an order that the state of Pirana, instead of placing people with disabilities, women and children with disabilities in institutional care homes, the state of Pirana is tasked to find the people who are killing and mutilating these people and place these people into an institutional record prison so that women and children with disabilities are free to live happily in a day-to-day society. In conclusion, to sum up our first claim, we have noted the violation of the right to equality and non-discrimination, the violation to the right to family, the violation to the right of a parent to choose a school for their own children and education for their own children, and the violation to the right to association. If we pray that the court is in agreement with the applicant that the state of Pirana is indeed in violation to this right. I will leave the same to my co-counsel to articulate claim 2.
If it pleases this honorable court, my name is Tatenda Masaranga. With the indulgence of this honorable court, the applicant still has the conviction that this honorable court has the jurisdiction to hear and determine this application before this honorable court. If it pleases this honorable court, the applicant shall proceed to substantiate our claim 2 on our application. In doing so, we have broken down the claim in 2 parts. Firstly, a violation of the right to health and the right to life, and lastly, but not least, the violation of the right to access to justice. If it pleases this honorable court, I shall proceed on the first part of the claim 2. The applicant submits that the failure by the Republic of Pirana to bring the killings and the mutilations of persons with disabilities to halt was a violation of Schmitter's right to health as well as their right to life. In terms of Article 12, Sub-Article 2 of the International Covenant for Economic, Social, and Cultural Rights, member states are obliged to ensure enjoyment of the right to health. Further to that, Article 25 of the Convention on the Rights of Persons with Disabilities, member states are obliged to ensure that persons with disabilities have access to health facilities and medical care. Honorable judges, from the facts giving rise to this case, Schmitter was raped, and when she was taken to a hospital by the villagers, she was denied health care facilities by the nurse in charge. The denial was based on nurse in charge's own judgment on Schmitter's relative work, based on her disability. We submit that that was a violation of the right to health as enshrined in the same provisions. On this note, Schmitter later on died as a result of health complications because she had not received any medical attention from the hospital. Therefore, the applicant submits that was a violation of Article 16 of the African Charter on Human and People's Rights, which provide for the right to life. If it pleases this honorable court, we shall proceed to make our submission for the second part of Claim 2. The applicant submits that the failure by the Republic of Peru to put in place good practices in accessing justice was a violation of Mola's right to access to justice. Article 7, Sub-Article 1 of the African Charter provides that member states must provide mechanisms which ensure that justice is accessible by all. Furthermore, Article 13 of the Convention on the Rights of Persons with Disabilities provides that member states must ensure that persons with disabilities have access to justice. From the facts, honorable judges giving rise to this case, Mola's right access to justice was violated. And this is because, firstly, the court proceedings were not explained to her. Secondly, the prosecution authority called a support person who was not only incompetent but unqualified. This led to the acquittal of the accused person because of the misinterpretations of the court on the narrations by Mola. Therefore, the applicant submits that there was a violation of the right to access justice. With your indulgence, my lord, and if it pleases this honorable court also, I shall leave this time for my co-counsel who shall present and make our submissions on the third claim.
Before you do that, counsel, when we look at the facts of the case, it seems that there's been some improvement. For instance, the number of people killed or mutilated started to diminish because of the stance taken by the state. So what can we say vis-a-vis progressive realization of rights?
Indeed, there are notable improvements. Firstly, from these two occasions, that work of Schmitter and Muller, there is no record of the mechanisms which have been put in place by the Republic of Peru to ensure enjoyment of these rights. And the applicant admits that economic, social, and cultural rights are progressively realized. However, the state is obliged to, within the limits of the resources available, to ensure enjoyment and realization of these rights. Please, this honorable court.
The state seems to be a poor state, so how can they be expected to actually realize rapidly, given that the rights are contextualized in the realm of the limits of their resources?
The applicant would like to inform this honorable court that the Republic of Peru have got minerals, natural resources from the World Bank report, which means that the Republic of Peru is financially capable of ensuring that these rights are realized by its citizens. If it pleases this honorable court. I leave this time to my co-counsel to make submissions on 10.3.
May it please this honorable court. In articulating and substantiating the Chiramba Nyasha, is still my name, honorable judges. It is the belief and conviction of the applicant that the application before this honorable court is substantiated, and the court has the role to determine the violations of international human rights law by the respondent in the matter in castle. And in substantiating the third claim which has been brought off record by the applicant, it is the submission of the applicant that the respondent is in violation of the right to personal security of the people of Perano, particularly women living with disabilities, children living with albinism, and people in general living with disabilities. It is the submission of the applicant that Article 9 of the International Covenant on Civil and Political Rights, read together congruently with Article 3 of the Universal Declaration of Human Rights, not forgetting Section 52 of the Constitution of Tirano, which entails that, particularly on Section 52C, as the spirit borrowed from the international conventions, that every person has the right to dignity in their private life, and the right that they have should not be subjected to medical or scientific experiments or to the extraction or use of their bodily tissues without their informed consent. It is the submission of the applicant that the question before this honorable court on determining the violation of international human rights law, particularly to the articles that the applicant is referred to, is on the phrase and the interpretation of the phrase informed consent. Of persuasive value, my lady and my lord, the applicant would like to draw the attention to the decision of the Inter-American Court of Human Rights in the case of Zimbabwe and Birch versus the United States of America, wherein the court held that informed consent mean that the state would have given and would have awarded enough resources and knowledge and invested in its citizens that they have a pure understanding of what is supposed to be decided on before they just make a decision. And there is a difference between just mere consent and informed consent. This would allow the applicant to further bring the attention of this honorable court to its decision in the case of the beneficiaries of the late Nobel Songo and others versus the Burkina Faso, wherein the court held that there is need and essential need for the court to ascertain an informed consent between the respondent state and the victims alluded to. My ladies, honorable judges, we humbly remind this honorable court that this is a public interest case in which the applicant is a non-governmental organization, bringing forth and arguing before this court that the respondent has failed to institutionalize the concept of informed consent before this honorable court. And the fact sheet particularly, they fail to attestate to that position. It is the submission of the applicant that the respondent is in total violation of the right to personal security. My honorable judges, within the time available for the rebuttals, we believe as the applicant these would be our submissions, and therefore we pray that the respondent be found in violation of, firstly, the removal of women with disabilities and children living with albinism from their homes, placing them into institutional care and attending schools and temporary shelters meant for learners with albinism only. Secondly, that the respondent's failure to bring the killings and mutilations to halt of people living with disabilities and failure to put good practices on the access to justice is a violation of the international human rights law conventions and provisions of record. And lastly, that the respondent failed to uphold the principle of right to personal security, particularly in promoting genetic testing for the OCA as a violation of international human rights law. It has been the last submission before this honorable court that may the court determine that the applicant has solely locus standi in judicia to be entertained before this court, and that it has jurisdiction to entertain this matter after classifying and quantifying the admissibility rules of this court, which have been satisfied by the applicant before bringing this matter before this African court, and mandates the respondent to pay and oblige and uphold the spirit of the charter, which has brought us before this honorable court. If there are no further questions, my ladies and my lord, these will be the submissions of the applicant.
You are simply seeking a declaration. And if so, what are the requirements?
Thank you, my lord. The applicant seeks that there be a declaratory order to compel the state of Perano or the respondent in this matter to be held in violation of these international human rights law, and particularly to take the same spirit that was taken in Serag versus Nigeria is to compensate the victims, particularly the victims of the late Shimita. And I'll then again persuasively refer back to the decision in the case of the beneficiaries of the late Nobel Zongo and others versus the Burkina Faso.
The gist of my question is, can you articulate the requirements of the declaration?
Noted, my lord. We humbly submit that once there is a violation, for the requirements for a declaration is that we need a violation to be present. And the violations have been put on record. Secondly, we need the court to make a determination on the violation after entertaining the principles and the procedures which the court has been granted because of the deposition of a declaration by the respondent state as to allow this court to have jurisdiction to entertain this matter.
Perhaps my question is on your last submission on the merits. You say that you are challenging the fact that there is no informed consent. Did I get you correctly?
Indeed, my lady.
What is your response to the allegation or to the finding by the High Court that there were radio announcement publicizing this program? Would that not be the giving of information to the public by the state?
most endangered. The question that arises is the difference between mere consent and informed consent. The action done by the respondent, it is the submission by the applicant that it was not enough. If we go back to the decision of this very same honorable court, in the case of Reverend Tikiwa and others versus the Republic of Malawi, it was clearly stated that an African state which has deposited its declaration before this court, when a violation is being claimed either by an individual or a third party in public interest, particularly looking into the issues of social, economic, and cultural rights, there is need for the state to abide to the procedures that have been set out, particularly in Article 23 of the Nuremberg Principles on the realization of economic, social, and cultural rights. Therefore, it is then the submission of this honorable honorable applicant that whenever we're looking at this, or whenever we're looking at the publication and announcement of this procedure, we need also to attestate that there was a language barrier, which also affected some of the people, and off record, it affected Shmita. So we then submit before this honorable court that it was publication, and publication was not enough to suffice informed consent, which this honorable court has made determination, particularly respecting the principle and spirit of the African Charter and the principle of Ubuntu.
Thank you.
If you may please, this honorable court, my name is Rufaro Deshe, and I'm the lead counsel as a representation of the respondent in this matter between the Forum for Women with Disabilities versus the Republic of Perano. Firstly, my ladies and my lord, I would like to put it on record that the respondent will not contest the issue of locus standi and jurisdiction of this court to hear this matter, as is apparent in terms of the provisions cited by the applicant. Now, the applicant has submitted that all requirements of admissibility of cases before this court have been met, and the respondent wishes to put it on record that it has reservations in this matter. But firstly, before anything else, the respondent would like to put it on record that it does not condone the violation of fundamental human rights of all people, including the rights of persons with disabilities, and is taking progressive measures to ensure that the rights of these persons are protected, promoted, and fulfilled, as will be satisfied by my co-counsel. Now, moving on to the aforementioned preliminary issues of admissibility. With regards to admissibility of this matter, it is the respondent's submission that the applicant has failed to meet the requirement of exhaustion of local remedies in terms of Article 56.5 of the Banjul Charter, which states that communications must be sent after exhausting local remedies unless it is obvious that the procedure will be unduly prolonged. Now, my lords and my ladies, the applicant has submitted that all requirements has been met, but has failed to seek audience of the Constitutional Court of Perano, and in this regard has not exhausted local remedies available to it. I will refer you to paragraphs 27 to 29 of the fact sheet, which show firstly that the applicant has not exhausted local remedies, and secondly that it is responsible ultimately for unduly prolonging proceedings. The applicant has failed, and willingly so, to comply with the rules of procedure of the Peruvian Constitutional Court after twice being given specific instruction to ensure that it seeks authorization of the victims that it sought to represent. Now, my lord and my ladies, in light of this, while they claim that the victims have been heavily guarded, as in paragraph 28 of the fact shows that the applicant was simply hesitant and reluctant to seek authorization. There was no positive step taken by the applicant to get the authorization, and in this regard, my lord and my ladies, I will direct the court to the case of Arriva Justice Council versus Ethiopia, Communication 299 of 2005, which states that apart from casting aspersions on the effectiveness of local remedies, the complainant has not provided concrete evidence and demonstrated sufficiently that these apprehensions have that they could not and has not demonstrated sufficiently that they were unable to exhaust local remedies. The relationship, my lord and my ladies, between supranational borders and national borders should be complementary. And in this regard, the principle of complementarity stipulates that when a national body is capable of producing the necessary remedy, it should do so without an international body getting involved. It is on this basis that we cite the case of Rikote African Power Law versus Zambia, where the Commission reiterated that the respondent must always have an opportunity to give redress by its own means within the framework of its own legal system. And it is also on this basis that we would invoke the doctrine of margin of appreciation, which was stated in the case of Prince versus the government of South Africa, where the court reiterated that the margin of appreciation doctrine informs the African courts that it recognizes the respondent state in being better disposed in adopting national rules, policies, and guidelines in promoting and protecting human and people's rights, as it indeed has directed and continuous knowledge of the society, its needs, resources, economic and political situation, legal practices, and the fine balance that needs to be struck between the competing and sometimes conflicting forces that shape its society. The applicant said,
before you proceed, when we look at this, the effects of this case and the hostility and the difficulties that the applicant actually faced, which are apparent, the institutionalization of persons, the statements made by the minister, and generally the difficulties of actually accessing the constitutional court, can we therefore then put blame on the applicant in trying to seek relief outside the state's legal system?
Thank you, my lady. I will again refer you to paragraph 28 of the facts of the matter, which gives the reason given by which states that the applicant was simply hesitant and reluctant to seek authorization. The applicant approached the Constitutional Court of Perano twice and twice failed to comply with the rules of procedure. Now, if we look at the domestication of international human rights articles by the Constitutional Court of Perano in 1995, it shows that the Republic of Perano is willing and ready to domesticate and give redress, as per paragraph 5 of the fact, and give redress to the applicant for the violations that it claims have been violated. So in this regard, the applicant has simply failed to take steps to ensure that it gets the redress which is already effectively available and efficiently available in the constitutional and legal framework within the domestic legal framework of Perano. The applicant, according to paragraph 28, as already mentioned, is simply hesitant to follow procedure and averse that the Perano legal system may possibly be compromised. And this is not a legal basis on which it may come before this court and claim that they could not get efficient and effective remedies from the local court in Perano. This is an act of casting aspersions on the effectiveness of local remedies, and the applicant has not provided concrete evidence to demonstrate sufficiently that the apprehensions are founded and may constitute a barrier to its attempting local remedies. I've already stated the case of Arivak Justice Council versus Ethiopia, in which the court stated that it is incumbent on every complainant to take all the necessary steps to exhaust local remedies of the courts. It is in this regard that the respondent states that the applicant has evidently and willingly failed to exhaust local remedies, and therefore this matter cannot be admitted before this court. It is our prayer, therefore, my ladies and my lords, that this court should not condone the failure of the applicant to comply with the rules of procedure of firstly of the Peranian Constitutional Court, and secondly of Article 56(5) of the African Charter, because what the applicant is doing is simply undermining the respondent state's ability to give domestic redress to the alleged violations, as has been satisfied by the demonstrations I have given the court. We therefore pray that this matter be dismissed on that premise. But if the court still decides to hear otherwise, my second counsel will address it on claims 1 and 2.
So, Counsel, are you saying that the applicant is merely forum shopping in terms of approach to this court?
My lady, thank you very much for that question. The applicant, again, has failed to make sure that it exhausts the local remedies provided to it. The Peranian legal system has taken steps to ensure that it domesticates the international human rights treaties that it has ratified. And that in itself is a positive step to ensure that redress will be available to the applicants if they approach the court and seek redress with relation to the violations that they claim have been perpetrated against persons with disabilities. This court can therefore not condone the failure of the applicants to exhaust those remedies first, which are readily available and accessible to them. They have simply willingly failed to do so. And if the court then proceeds to admit this matter, it would be condoning their failure to exhaust local remedies.
So in other words, what would then be your position as regards procedure vis-a-vis the substance?
My lord, the substance.
You understand the question?
Yes, maybe you can.
Yes, in other words, it's a follow-up to my sister's question there, that are you saying we should simply close the door because the parties failed to follow procedure and ignore the substance?
What we are saying is that the domestication of the international human rights treaties, which this court has jurisdiction to hear, by the constitution, by the Peranian legal system, already is a positive step by the state to ensure that it gives assurance that it is willing and ready to address issues to do with violations of fundamental human rights of all persons, including persons with disabilities. Because also in the facts of the matter, in its Declaration of Rights, the Peranian Constitutional Court has made sure that the fundamental freedoms and human rights contained in the African Charter and the CRPD are domesticated. So this is a positive.
I'm simply saying that if you read those paragraphs which you were referring to, what has caused the applicants to approach this court is that the difficulties in terms of procedure. So if it is a proven fact that there are those difficulties, is it your argument that we should, on the basis of procedure alone, close the door and ignore the substance?
Thank you, my lord. Respectfully on that again, we have been told that the Forum for Women with Disabilities was simply hesitant and reluctant. We have not in any case been given evidence of the fact that they approached the person with disabilities. Of course, we do acknowledge that the places are barricaded, and this might, and according to the applicant, they might not be able to access the victims, but they have not tried to access the victims. And in this regard, we cannot therefore say that they have exhausted local remedies. Thank you.
If you may please, this honorable court, my ladies and my lords. As already has been alluded to by my lead counsel, I answer to the name Inko Majoko, and I am the second counsel to address the petition. Majoko, my lady. And I rise at this particular juncture to address the issues or claims on issue number 1 that has been raised by the applicants today. So the applicants have alleged that the Iranian government has violated the right for children not to be institutionalized, that they have violated the right to non-discrimination, the right to family, and the right to education. I propose to structure my response and submission as follows. I'm going to start by addressing the first issue to do with institutionalization and ensure that the state is indeed acted in the best interest of the child by preserving the fundamental human right to life. It was stated in the case of African Court of Human Rights, in the case of Human Rights Commission versus the government of Kenya, that the fundamental human right of life is the fountain upon which every other right is enjoyed. If we refer to paragraph 21 of the text, we see that the motivation behind the State's Act lay in protecting children that are being mutilated as well as children that are being killed. Thus, it was a reasonable justification for the State's action in preserving the rights of children. We also note that in terms of Article 11 of the African Charter on the Rights and Welfare of Children, states are mandated to take positive action in times of risk and protect children. This the state did, and thus the state cannot be said to have violated this principle. My ladies and my lords, I also address this honorable court on the issue of discrimination. We heard from the opposing counsel, from the opposing delegation, that the discrimination point that they want to make before this honorable court is on the basis of gender, and that there is no evidence whatsoever that women are the most vulnerable gender in this particular case. But I refer the leadership in note to the pertinent paragraphs or paragraph 14 of the text, which stipulates that there is a high prevalence of women who are vulnerable to these mutilations and human rights violations, and thus the state cannot say to have acted unreasonably in these particular circumstances. It acted to protect those that are most vulnerable and is still in the process of protecting those that are most vulnerable. The applicant has also advanced an argument that there is no violation of the right to family, but the applicant fails to take note of the fact that these rights are taken holistically within limitations that can be placed upon by the state to preserve and protect the best interests of the child. It was stated in the case of Kunati versus Burkina Faso, which I citation provided for is application number 004 of 2018 before the African Commission of Human Rights, that the right to family can be limited when the state passes the test of proportionality, reasonability, and justifiability. I also invite this honorable court to take into cognizance a report which is published by UNESCO in collaboration with the non-governmental organization based in Tanzania called Under the Same Sun, which was published on 23 April 2013, which states that persons living with disabilities not only face violations from communities but also from their families, who in that report is stated that they were selling their body parts for 20,000 USD on the black market. Thus, the state was acting in the best interest of the child by placing them in a temporary environment that allows the state to find a more permanent solution while this is dealing with this human rights violation. It is our submission before this honorable court that the applicant has failed to satisfy before this honorable court sufficient evidence that the state acted unreasonably and unjustifiably, if given the fact that there were human rights violations that were taking place, and especially the right to life had to be preserved. I will also tend to address the honorable court on the alleged violation of the right to education, which is advised by the applicant. It was also
perhaps before you proceed, you argue that the state has taken reasonable measures, but do you see that the period of in which these people are placed within these institutions is indefinite? do you still persist that such a measure, being indefinite, is a reasonable measure?
Most obliged to answer that question, my lady. Yes, it is our submission that the measure is still reasonable, given the fact that they are preventing social rules that are deep-rooted in superstitious beliefs. Unless the state is provided sufficient safeguards for these children to be integrated back into society, their right to life will be undermined. And it is our submission that to preserve this utmost important right to life, the state should continue to provide security first to their right to personal security, and in trying to find a better way of protecting these rights. If your ladyship is satisfied. Thank you very much, my lady, for that indulgence. On the allegation of the right to education, on the violation of the right to education, it is our submission that the right to education, the legal question which the court should be seized with is whether or not the state of Pirano has met its minimum core obligations. It is right that the right to education is subject to the principle of progressive realization of human rights. And if we take into account the fact that the state of Pirano, in terms of paragraph 8, is a struggling economy, it has an obligation to provide for certain basic standards, which it has done. And in terms of Article 24 of the African Charter on the rights and welfare of the children, it is provided for that these basic standards include the basic education, and the state has done so. What the applicant are calling for, my lady, my lord, is the full realization of this right to education. But it is also submission that the state cannot be held accountable, especially when it doesn't have the financial capacity to carry out those human rights to the full realization that they seek. And they've stated that the state of Pirano has diamonds, but that in itself does not translate to these diamonds being utilized for these diamonds translating to law, which the state of Pirano can use to protect these human rights. On the question, therefore, of whether or not the state has met its minimum obligations, it is also admission that yes, it has met its minimum obligations, and it is in the process of progressively realizing these rights to ensure that these children and persons with disabilities are able to enjoy their rights under the Charter.
So if we look at the major principles of human rights, non-discrimination, inalienability, divisibility, and so on, can you say that the state really, by putting persons in temporary shelters and all other measures that the state is taking, if we then reflect them against this internationally recognized international human rights standard, how would the state feel?
Most obliged to answer that question, my lady. It is our submission that while we take into account that these measures may not be the best measures in some instances, in this particular case, because of the peculiarities of these facts which are prevalent in this particular case. And if I may invite the Honorable Court, the Honorable Lady, to the case of Prince versus the government of South Africa, which my lead counsel has already cited, it stated that the state is in the best position to understand some of the situations, some of the instances which occur on the ground, which independent persons may not understand. So it is our submission that under these present circumstances, the state indeed has limited these rights reasonably and justifiably. If that satisfies her ladyship's intervention. Unless I may be of no further assistance to this honorable court, I seek leave to defer proceedings to my learned co-counsel, Ms. Odrido, who is going to address the honorable court on claim number 2.
Thank you, this honorable court. As already been enunciated by our lead counsel, I respond to the name of Odrido. And I shall be addressing this court on the second part of claim number 2, which addresses the applicant's assertion that the state in denying persons with disabilities access to justice violated Mueller's right to access justice. It should be noted by this court that the state does not condone the denial of access to justice to persons with disabilities. We accept that this is a fundamental human right, but however, this right is subject to progressive realization because of the state's current economic status. I will refer the court to paragraph 8 of the fact, in which it is shown that the state of Pirano is a developing country and is struggling economically. Measures to ensure that disabled persons are afforded a fair trial are costly to put in place. I will also direct the attention of this court to Article 2, Sub-Article 1 of the International Covenant on Economic and Social and Cultural Rights, which obligates state parties to achieving progressively the full realization of the rights recognized by the present Charter by all appropriate means, including particularly the adoption of legislative measures. It is in light of this provision that the respondent contends that the state is taking all possible measures permitted by its economic situation to provide means to ensure that persons living with disabilities access justice. In conclusion, the state is not denying the disabled person's access to justice, but it is working on addressing all these measures required progressively. For developing states that is struggling economically, the measures it has already taken to ensure that disabled persons live a better life are a lot. The state has already provided sunscreen lotions for persons with OCA and has erected temporary shelters to safeguard the lives of disabled persons. And already, this is detrimental to the fiscus of the state. It is only human to allow the struggling states, time to address the issues pertaining to persons with disabilities, taking into consideration its economic status. If I may be of no further use to the court, I shall defer proceedings to our fourth counsel, Ms. Rebecca Mabushimwe, who is going to address this court on claim number 3.
The council, we are looking really at children. If you look at Mula, a 14-year-old girl, and then Shmita, who was 16, and then she subsequently died. And when we look at the CRC, it states that they are really supposed to, they fall under the category of minors. And when we look at CRC, which is the convention that has been ratified by the most number of countries in the world, and it's supposed to protect these children. And then the state is saying progressive realization, we've done this, we've done that. When you look at the rights provided in the CRC, what do we have to say about the violation of the rights of these minors?
Most obliged, my lady. We agree that the rights of minors have been violated, but we also do not dispute that the state has been taking measures to ensure that minors are not subject to violations by persons. We can look at the fact that the state in its constitution provides that in section 25 of the constitution that the crime of rape should not be committed and persons who commit rape should be prosecuted. In this case, I'll refer again to Article 2, Sub-Article 1 of the International Covenant on Economic and Social Rights, which states that state parties should take steps to the maximum of their ability. We're looking at a state that has already been doing things to ensure that the right to life of disabled persons is not taken. We're looking at a state that has been looking at measures to ensure that disabled persons or persons living with OCA receive sunscreen lotion so that they do not develop cancer. All these things are being imputed upon a state that is economically unstable. And if we look at what the respondent said about how the state already has diamonds, we can look at the fact that diamonds are a natural resource. And according to Paul Guinness in his A-level book of National Geography, it states that natural resources are any part of the Earth's surface that can be used to benefit and sustain human life. Part of the Earth's surface do not determine the money that is currently in the fiscus of the state. So even though children's rights are being violated, we agree to the fact that children's rights are being violated, but we should also look at the steps that the court is taking to ensure that disabled persons access justice. In this case, Mula was afforded a special educator, a person who could interpret what she wanted to say. It is not stated that these measures should be perfect, but it should be noted by this court that the state is taking measures and it's taking progressive measures, and it will take time because these violations do not start today, and this state is faced with a lot of things that it has to do. If I may be of no further assistance to this court, I'll defer proceedings to our last counsel, Ms. Rebecca Mabushimwe, who will address the court on claim number 3.
If it pleases this honorable court, honorable justices, my ladies and my lord,
My name is Rebecca Makoshongwe, as already been articulated by my first co-counsel. I shall be addressing the court on the third claim of genetic testing of LCA in relation to international human rights law. Now, to go into the detail of my submissions. The first issue to understand is that genetic testing shall be optional, and any findings afterwards and actions shall be up to the discretion of the woman who would have undergone testing. This is in no way discriminatory. It is a means to protect the financial positions of these women and the state, because taking care of people with special needs is expensive, particularly in a low-income country such as the Republic of Pirano. Further, the most important duty of the state is to protect the right to life. My ladies and my lord, this duty is best upheld if the state can eliminate anything that may harm or threaten that life. The right to life is best understood within the framework of enjoyment according to Articles 19 and 24 of the African Charter on the welfare of the child. In accordance with enjoyment, it is reasonable to assume from the current statements of facts that people living with OCA have minimal enjoyment of their right to life. Paragraph 14 of the fact sheet states that persons with albinism in Pirano have historically experienced insecurities with their life, health, education, and employability prospects. Now, although as the government we do not condone these acts perpetrating harmful cultural and social practices in line with Article 21 of the Banjul Charter, we do acknowledge that these unfortunate events do happen. As stated in General Comment number 6 of the UNCRPD on equality and non-discrimination. It is on this basis that as the Republic of Pirano, we believe it would be in the best interest of the child and their parents with OCA to prevent further births of children with OCA so as to protect them from some of these violations. If a risky pregnancy can be prevented, it is in the best interest of the parents that we at least provide sufficient knowledge and they can have reasonable grounds on which to base their decision. They too deserve to make an informed medical reasoning. It is no secret that the people with disabilities have special needs and special expenses. Hence, we provide the option of genetic testing in order to safeguard them against some of these challenges. In the interest of time, I shall move on to our relief and prayer sought. We as the respondents are saying, we pray that this honorable court rules that this case is inadmissible. If this honorable court finds this application admissible, we pray it may be dismissed on the following grounds: that the applicants have failed to exhaust all local remedies before approaching this honorable court. Further, the applicants have failed to satisfy requirements of what is accepted as a violation to the rights of life. The state has also not institutionalized albinism as shown by our submissions. We pray that the applicants be found in violation of Article 25 of the Banjul Charter by failing to exhaust local remedies and follow procedure. Secondly, Article 18 of the CRPD has been violated by applicants. Thirdly, Articles 19 and 24 of the African Charter on the rights and welfare of the child has been violated by our applicants. Finally, we pray that this application be dismissed in favor of the respondents. If the court may indulge me, may I seek extra time? Thank you. Now, in assessment of the arguments brought before us by the applicants and us as the respondents, I shall address a few points. Going on, the applicant provided that African Human Rights Commission obtained observer status in 2015, hence they claim they are able to bring the case before this honorable court. We as respondents do not contest the issue of jurisdiction in this matter. However, the application must fail because they failed to exhaust local remedies, thereby undermining the sovereignty of the Republic of Pirano. This sets the wrong precedent for future cases. They also mention that the claim for all requirements of admissibility have been exhausted because local remedies are not available. We as the respondents are saying local remedies are only unavailable because they failed to follow procedural law. They were simply hesitant and failed to obtain authorization from the victims. They claim that women with disabilities and children with disabilities are being kept in camps similar to the situation in Nazi Germany. As the applicants have admitted, that is simply a historical finding in a court of law. However, we as the respondents continue to say our main concern is the right to life, and as shown by my co-counsels, this right should be interpreted broadly. This means in understanding the right to life, we must assess the quality of that life. States are mandated to take positive action to protect the right to life, a measure which the respondents have tried to satisfy. Further, the applicants claim that the state of Parana only took women and children into camps, thus prejudicing men. As my co-counsels have already alluded, this measure was taken because women face a double tragedy of discrimination on the basis of their gender and their disability. Moreover, the applicants submitted that the right to family is being violated by separating children from parents, and parents have the right to choose the educational facilities for their children. As the respondents, we are saying the right to life is absolute and comes first before the implementation of any other right. For one to enjoy all these other rights, they must be alive. Hence the justification of parents taking children into protected camps. On that basis, we rest our case. If I may be of no further assistance to the court.
The court will briefly adjourn for 15 minutes.
Can you take the rebuttal first and then wait for 5 minutes to do the rebuttal?
If it please this honorable court, we shall make rebuttals on the preliminary objection raised by the respondent. The applicant strongly disagrees and rejects the respondent's argument that the applicant did not satisfy the exhaustion of domestic remedies rule. The applicant argues that domestic remedies were not available in the Republic of Iran. And the case of Almak Justice Council versus Ethiopia is very instructive in that regard. The African Commission on Human and People's Rights stated that a remedy is considered to be available if the applicant can pursue them without impediment, or if he can make use of them in the circumstances or his or her case, in his or her case. So, in the applicant's circumstances, the applicant cannot make use of the domestic remedy because the victims were heavily protected. And paragraph 30 of the fact sheet clearly stated that the applicant made futile attempts at vindicating the alleged violation of fundamental rights. It is very clear that the applicant cannot make use of domestic remedies in the Republic. Therefore, the exhaustion of domestic remedies rule is satisfied. The applicant's matter is admissible before this honorable court. If there are no further questions, I shall defer the proceedings to my co-counsel to present some rebuttals on merits.
Also, you've got 5 minutes.
Thank you.
Please.
May it please this honorable court, Chiramba Nyasha still remains the name. It is the submission of the applicant that the submissions by the respondent, particularly to claim one, fatally depicts the position of the respondent in respecting, promoting, fulfilling the principle and spirit of the African Charter and the spirit of international human rights law. It is the submission of the applicant that through the submission of the respondent, particularly on the issue of availability of resources, it is tried before this court that the respondent is a very poor state. However, The submissions by the applicant are notched on the position of an undue prolonging of procedure. If there is realization of rights in terms of economic, social, and cultural rights convention, my honorable judges, the applicant still goes back to the sacrosanct condition that was set out in Article 23 of the Limbe Principles on the realization of social, economic, and cultural rights. Therefore, it then gives a challenge in order to understate the reasonableness of the limitations that were proffered in an attempt to calculate a progressive realization procedure. The Limbe Principles are clear. We need a time frame. We need a project. We need an outline from this stage to that stage. The state has just given, say, a temporary, but not stating for how long the temporary stretches, for how long the temporary institutionalization is going on, let alone prosecution has never been seen existing before the soil of Verano, giving rise to the position of the applicant approaching this honorable court. It is the submission of the applicant that, particularly looking at the third claim on the respondent submission, will allow the court to draw its attention to Article 37 of the Universal Declaration on Human Rights and Article 48 on Section 48, subsection 3 of the Constitution of Iran, which awards a sacrosanct, non-derogable right to life of the unborn children, let alone they are contesting on economic grounds. The resources available, the time that was wasted, it is the applicant's submission that, despite having a poor status, the resources were the time that the respondent has been allowed. It would have been key to at least move on a better scale without allowing a prejudice which is uncouth, which has been labeled and understood by the applicant just and then provide communication before this honorable court. I'm aware I'm out of time. If I may seek 30 seconds, honorable judges, most dated. There is a serious grave miscalculation by the submissions of the respondent insofar as the resources available in Perano is concerned. They are alleging that the second claim, the access to justice, was proffered because the resources available were not limiting us. We would then submit before this honorable court that the resources were available, but there was an incompetent person who was appointed to deal with this matter, and the facts are very clear. It's on record, honorable judges. So this is the reason why the applicant has sought audience before this honorable court. We understand the position of the respondent, but may this court be also derailed to the position by the very same respondent in the case of Mildred Mapingule versus the Minister of Home Affairs and another, wherein such an incompetence was dealt with and the victim was compensated. And as of now, such an incompetence is prima facie, let alone we are living in the dark. My ladies and my lord, may this court determine the violations of international human rights law that is before this honorable court, proffered and perpetuated by the respondent. These will be our submission. Thank you.
The court will adjourn for 15 minutes. All rise. Okay, ladies and gentlemen, you can take your seats. Now we are going for a tea break, and kindly be reminded that it's strictly 15 minutes, and our tea will be served on the room which is on my right, the first room on my right. Remember, 15 minutes only.